Right. Okay. So pleasant good morning to those of us who are joining us on the I guess on the platform, whichever platform we have decided to use. We normally use the Google Classroom platform, but I have mentioned to you all that this particular, so Christina had it as well. Very good. Okay, Desiree, I see the point that you made, right? Okay, so we have asked two questions before and you all have answered them well. Remember, um NEBOSH don't really ask what I am asking you, right? Like, what is the HSC? We just kind of revise it anyway, right? So here's a kind of tougher one, but I guess on the day of the real exam, you'll have your book, but maybe something stuck with you last week, right? So anyone could see if you remember like one or two powers of the inspectors. Like if you were an inspector, an OSH inspector here in Trinidad or in Guyana, what are some of your powers?
They have the power to shut down businesses,
Very good. And some of
give
them have
improvement businesses also.
very good, right? So very good there. I think you give more than two answers there, right? So yeah, they have the power to close businesses. And you also did mention the notices, right? Anybody remember the fee for those notices in the UK, which is what we have to quote in this course? Anybody remember the fee for like a fine? Like what is the value of the fine? We had it drawn on the board many times, the whiteboard or the slide itself. What was the fees for the fine? If
About
that makes sense.
£20,000.
Very good. 20,000 pounds, right? Okay, excellent. So you all are doing very good. I would love love. Okay, very good. Lyndon has it as well, right? Kavita has it as well. So excellent point there. As I do say, not everything is for exam, but those things could be, and those things could be like an indirect cost. Those things could be like the uninsured costs. That is how you could use those figures. All right, if you want, we could open the book. We'll try to get onto today's book. So thanks for that. You all answered more than 5 questions, which is good. Um, I do say NEBOSH is not hard, but you have to know how to answer your questions, right? And we have kind of done one already. I think you had one good assignment. I say good because the other assignment you had, the one on the ACOPs, that was for more the project. That wasn't for the exam. Remember finding the ACOP and the guidances, and you all did well on that. But that wasn't an exam question. That was like the project. That's something you have to do on the project form itself. Right? So I think you had one good question. So today, um, probably wonder why I signed, right? So today, there are some things, last week I said it too, there are some things that are very interesting, but there aren't too much questions on it, right? And again, today is like that. So I think we did FIFA intervention already. So we can pick it up today. I'll pick it up on this slide, right? But really the meat of today's work is around page 16 in your textbook. And for this one, to be honest with you, I'm gonna just try to line up this slide with it too, right? For this particular part today, I do think we could finish chapter one today also, right? So chapter one may be finishing today. Uh, but in terms of past papers, this is not a heavily tested part, the part on common law, right? So we did this was the powers of the inspectors and stuff, right? So the part on common law here, right? Civil liabilities, right? Folks, it have zero past papers. Not zero past papers again doesn't mean, it's like CXC, right? Zero past papers does not mean that they probably would never have a question on this, right? Because it is a syllabus, right? But to date, then there are no past papers on this. So what I'll try to do, we'll do this today, but yet again, there wouldn't be any class assignment then because there is none to give, unless if I make up a question and I don't want to make up a substandard question. This is very good stuff here, right? You'll see it in your book, page 16, 17 is what we on, right? Taught for negligence and stuff, right? Very, very good stuff. but no past papers for y'all, right? They do get this, students do get this in the level 6, the NEBOSH diploma, and maybe y'all will be the first, who knows, right? This is May month. I do have the May paper here as well, but remember, it doesn't have a question on this, right? So, May month, which is this month, May the 8th was exam, and they did have some new questions, but not this. So I guess that's a step in the right direction, right? For those who know what I just said, I remember, um, I guess a CXC paper then, a CXC maths paper is like every other maths paper. You know, you're gonna get fractions, trigonometry, graph, whatever, right? So NEBOSH is like that. But in May here, I did see them. They had like about 2 new questions. Something on audit and well, it's in the book, right? But we never saw that question before. It wasn't a hard question, it was really easy, right? The case study had an auditor and they asked like what did the auditor did correct. So very easy. I mean, it wasn't hard, but it was new. So what I'm saying is that maybe that's a step in the right direction because all the other questions to me was the similar questions, but there are no questions on this, right? So without any further ado, let's make a start, right? Um, Let me just mute that one and we'll start here. Again, folks, thanks for coming in. I know that we seem to have a full batch, right? Remember what I said? Please remember that you can take off your cameras, have your breakfast, have your coffee, have your tea. Don't leave it off for the whole class, though, Vincent, right? Put it on ever so often so we could see you a bit, right? So let me shout out some of the people I'm seeing. I'm seeing Carlos, Lyndon, Desiree is off, but she didn't tell me why. Sadi, Kavita is there, and you all look studious this morning. Nairi is there. Amrika, Alicia looks very studious there. Shirley Williams look very studious. Oh, Vincent, you seem to be in the car, right? Siri, and of course, those in Guyana, I will be in Guyana next month. I did meet, the first time I met Vincent was at the Marriott in Guyana in February, right? Christina has a picture up, but I guess we'll sort that out, right? Adnan, good to see you. Nicola, Glenn, Steele, often looking like Steele as usual. Malini, Kimberly, Kimberlina. Glenn, don't smile at all, you know. I'm trying to get Glenn to smile there. Okay. All right. We have Cliff, Nishon as well. And Daryl seems to be on another planet, but I guess at least he can hear us. Or you seem to be from Stranger Things or any upside down, as they call it. All right. Okay, folks. So let's make a start, right? So I don't know where you want to start. It's the same thing. The book and the slide is the same thing. So I'll read the slide first. You can maybe look at the book. We go through like this, really good stuff, but stuff for the degree. If anybody going on to the NEBOSH diploma, or maybe, like I said, you're in your exam time, you may be the first to get a question on civil liabilities and civil law, but there are no past papers here for the history of past papers then, right? There are no past papers here. There are, but before the pandemic, and then the way of testing before the pandemic was different to now. So we had questions up to about 2019, but since the pandemic 2020 to now, there have been no past paper questions on civil liabilities. Stranger, really strange because when you read it, it's a really good part of the course, but I am not NEBOSH. Like your tutor would not have been CXC. So I am not NEBOSH. I'm just telling you what is what, right? Let me take it from the slide. So civil liability is tort of negligence. So this word is not spelled wrong, and that's how they spell it. If you check your book, you'll see it. A tort is a civil wrongdoing. I'll explain at the end. Negligence is when loss has resulted from a tort or a wrongdoing being committed. There is a decided case on this. In fact, there are many cases, but the main one, you can spot it in your book too. Let me see if you can see it on page 16. If you have a highlight, you can highlight it, right? The precedent case is Donahue versus Stevenson. And in this case, Mrs. Donahue, the claimant is the victim, right? The claimant consume a bottle of ginger beer that contained a decomposed snail. Let's see what happened to her, right? So I'll finish up the slides, and it's not really much to explain, it's just information anyway, right? The bottle was opaque, sort of, like a Heineken or I guess a Guinness or something, right? No one noticed the snail. Mrs. Donahue became ill, right? And sued the manufacturer, Stevenson, for negligence. So Stevenson, for us in Trinidad would have been like Carib then, right? That's the beer manufacturing company. And for those in Guyana, it would have been like Banks, right? Banks beer, which is actually a very good beer, right? So the judge, we have a Banks cup that I kept, right? I have it on me, but I wouldn't show you now. It'd be kind of strange, right? So the judge in the matter, his name was Lord Atkins. And what he said, he established, by the way, this judge is the one that defined what negligence is. He coined the phrase, well, he didn't coin the word negligence, but he coined the definition for negligence, right? I'm looking in the book and I'm not seeing it, but it don't have to be in your book because it's on the slide. And like I said, because this is not really examinable, I guess NEBOSH left that for the diploma students, but the definition is on the other side. I'll tell you what it says just now. The essence of the definition, though, is that he was saying that Mrs. Donahue and the supplier is in a relationship. What type of relationship? He referred to it as the neighbor relationship. So the question is, who is your neighbor? How is Carib or Banks your neighbor if you're not living close to the factory? Well, the thing is, what they say a neighbor is, good or bad, and in every village it have both, but a neighbor is someone that their actions could affect you. So that's what the judge was saying. Like if your neighbor is playing loud music, well, you are the one that's playing loud music, right? It could affect your neighbor, right? If your neighbor has an elderly um, family member, a baby, a child. Of course, those of us in Trinidad, I don't know for Guyana, so I could ask Vincent and Suri to shed some light. Folks, I see you all putting things in the chat. Remember, if it would take me some time to read the chat, right? Okay, so that's me, Young. Which I wouldn't really do if I'm teaching. I tend to focus on teaching, right? So yeah, so what I was saying, like the folks in Trinidad, we don't really, well, not really me. I just saying neighbors in Trinidad don't really care, right? About noise and like your neighbor may have other things and like if they have chemicals, if it's like a car garage, oil that gets washed down into the drain, if you are living downhill from someone, most people don't care. They have animals, they have dogs, they have goats, they have sheep, you know, they don't care in Trinidad. I'm not too sure if the same is for the other countries, right? But I know in Trinidad people don't really care. Neighbors don't really care. But the thing is, even if you don't care, you have a boundary then, right? And this is the thing what Lord Atkins was saying that like your neighbor affects you, right? So if the neighbor has an animal, a dog, sheep or goat or cattle, and it gets into your property then and eats up your crops or your flowers, whatever have you, your prize, flowers and whatever have you, your neighbor is responsible. And this is what the judge was saying. He was saying, so he said that even if they are the manufacturing company and that she drank a beer, and think about it too in Trinidad, that if you drink something from Carib and it had a foreign material in it, or if you drink a Banks beer in Guyana and it have a foreign material in it, in a way, you are affected. And if you are affected, well, then who affected you? It would have been the manufacturer, right? So he said that, and because of that, we now understand that to be the consumer and supplier relationship, right? Of course, you all know, in fact, if you don't know, this is today's class. the beer company would not have admitted to this. Remember, they would have defended themselves. They would have said things like, how could we have known what was in the beer bottle? How could we be responsible for every beer bottle? But the judge took her side. The judge said that they are her neighbor, and because she was ill, she must have been affected. And then if she is affected, well, then who affected her? It was the beer company. The long and short of this, if you all don't know, you all should remember this case. I'll tell you two reasons why, but afterwards, right? Because of this, this is what is called a precedent case. What is a precedent case? A precedent case means it is still applicable today. Precedent means doesn't matter if it's 2024 and this was 1932 back then. Precedent means if you consume, and I'll tell you two stories, just if you consume something in Trinidad or in Guyana, right? Just remember a third one. And you, maybe there's CCTV footage as you open the pack, as you open this product, something comes out of it, a foreign material, you can sue. And one of the reasons why you can sue is because of precedents. If you don't know what precedent is, precedent means that Mrs. Donahue, I think it's Miss Donahue, I don't know if it's Mrs., right? Miss Donahue has already laid the foundation for you. The courts in the world know this case. And if you know how civil law works in that if there is a precedent case, the judge today, the judge in Berbice, the judge in Siparia, the judge in the High Court San Fernando, but not in High Court. It may be High Court. It probably will be the Magistrates Court, right? The judge there today will have to follow this precedent. That's why it's called a precedent. So there's a memorial to her. I hope to visit this one day alive. This is in Scotland, right? This is in Paisley in Scotland. There's a memorial to Miss Donahue because of her action, bravery, because a lot of us may have just gotten sick and stayed sick, but she didn't stay sick. She sued the company, right? Because of her, every consumer today that has something in their product that wasn't, meant to be there, have a chance of winning a case. It's all because of Donahue versus Stevenson, right? So this is the Well Meadow Cafe in the late 1920s. This is the only picture, right? They have on online, right? This is probably the only picture of the cafe in May Donahue's time, right? Yes, her first name is May. May is a very much English name, right? Like one of the last prime ministers of England was actually May. Remember Theresa May? Anybody remember Theresa? That name sound familiar? Theresa, not Mother Teresa, but Theresa May was one of the prime ministers. So May, M-A-Y, and is of course the month of May is a very popular name in the UK, right? I advise all my students. One of them just came back. I can show you this, but I don't have it here. I advise all my students to go to England. You don't need a visa. You don't need, one of my students just came back 2 weeks ago, right? I'll show you some things that they bring for me. I normally have a thing with newspapers, but I don't have it here. I have it home, right? I have a thing with newspapers. I like to look at the newspapers. Those of us in Trinidad, what is the first thing in our papers? I may have a papers here, but not the one from the UK. I normally have an Express somewhere here. What is the first thing in Trinidad newspaper? What is on the front page of the papers?
Either murder or political something.
Yeah. And that's why I like to look, even in Guyana, folks, when I got back 3 from Guyana, but I don't have them in the office here, right? Even Guyana. When I was in Guyana, February, right? Part of the papers had a part on crime. You know what them crime news was on? Anybody could guess? What was the crime news on in Guyana? Anybody make a guess? Make a guess. The same in Barbados. Are the same experience in Barbados?
Trinidad crime, sir?
Yeah. In Guyana, crime section was on Trinidad. This is not a joke, right? I was driving in Barbados. Yes, you can drive in Barbados, right? I was driving in Barbados around lunchtime some years ago. And I remember hearing them say, coming up in news of crime. So I pull aside the vehicle to hear what is them crime news. Then they say, in Trinidad and Tobago, that Barbados crime news is in Trinidad as well, right? Now, England, when I was there, England crime news sometimes is something small, like stealing bicycles. That's like a common thing across there, stealing bicycles, right? So, um, the folks in Guyana, yes, you all have murders. There was a murder when I was in Guyana, but Guyana is a damn continent. Guyana is part of a continent. Right? So, and that one murder was not really crime. It was more linked to the oil, not the oil, sorry, the gold. It was linked to the gold, right? Somebody was trying to come out, I guess, a company extracted some gold and they were trying to come out of it, come out of where they got it. And I guess it was a setup, right? But it isn't as what we have here. So, Eddie was telling you all, yeah, that I do advise you all don't just all run to America now. Don't just all run to the to New York City, right? Haven't you on NEBOSH, have you all ever done what I told you all to do? Did you all ever check up to yesterday? I checked. Did you all ever put UK HSE jobs? Did you all ever do that and see that with your NEBOSH qualification? You don't have to work in Trinidad alone. You could work here because the accent right here. They ask for it in Guyana, they ask for it in Canada, but they could work in the UK, right? Anyway, back to the story here. But I do try to tell you, I have a student, Shelly. She just came back 2 weeks ago from the UK, right? And after, before her would have been Lysana Nichols, right? I do tell students, hey, go to London a bit. I mean, you don't need a visa, just save up your money, get your ticket. Living in purchasing stuff in London and stuff is even cheaper than Trinidad. Yes, you heard me correct, right? It's actually cheaper than Trinidad. Anyway, back to what happened here. Anyway, the point of telling you about London was to tell you about this pity that I guess out of the UK, out of London, a lot of the buildings do look like this. Yes, they do look, that part of the world is described as the old world, Christopher Columbus, this part of the world described as the new world. But even out of London, like London is a city, but out of London, like if you get into the towns, like where NEBOSH is, NEBOSH is not in London, NEBOSH is in Leicester, which is more like a town setting, right? There is this Leicester City center, right? But out of it, the buildings still look kind of oldish on the outside. When you get inside of them, they are very nice on the inside, but on the outside. So when I show you the picture, I don't want you to think this is like an old picture. Actually, parts of England still look like this, right? Still looks like that. Yes, it still looked like that. I remember coming out of a building. I went in the daytime and I came out like around 4 o'clock. But 4 o'clock in England is dark, right? When I came out, the thing looked like a haunted house. It looked like one of this. And I was like, wait, now that is where I was inside of. But inside was really nice. But outside, when I look back, I was like, this thing looked like a haunted castle. But that is what it looks like, right? So don't despise the picture. Even though they say 1920, the building probably still around anyway. And who knows, if not around, maybe there's another bar, another thing there, right? So the judge said, Lord Atkin, this is the definition of negligence. He said, please remember if you learn anything today, one of the things I wanted to do today, and if you can do it now when I'm teaching, is please check up UK HSE jobs, right? Remember today class don't have much passive, so we could deviate a little bit from here today. But it's all about giving you that experience to tell you that your qualification is worth it. This is not custard. This is not Cipriani that nobody here know. Like we can actually prove that here. If I ask my two Guyanese friends if they know what custard is, or if they know what UTT is, they don't know, right? They don't know. And they don't have to know because UTT is just local. And even if they say it's more than that, nobody knows what UTT is and nobody knows what COSTAT is. Telling you from experience. But we all know what NEBOSH is around the world, right? Let's see what the judge said. Remember, this is not something to learn, right? So the judge said negligence was defined by Lord Atkin in 1932 as a lack of reasonable care or conduct. So I think that could be in your book about the third line, right? But this is the full definition, a lack of reasonable care or conduct that results in a civil wrong or a tort, as a result of which loss, injury, or damage is incurred. Mrs. Donahue, what happened to her case? Mrs. Donahue, what? Mrs. Donahue won her case, and you would win yours too. Lord Atkins' neighbor principle that people must take reasonable care not to injure others who could foreseeably be affected by their actions, or in this case, their inactions. The inactions is a failure of the company to do a quality check. Now, because I've already told you 2 stories, I'm not going to tell you anymore, but I'll just tell you what happened, right? I won't go into details. I have had 2 recent students, one in PriceMart and one in KISS. Well, those of us who are not from Trinidad, our PriceMart is, I think, in Guyana too, right? I think they are. If not, PriceMart is similar to like Massey stores. It's an entity like that, like Walmart, right? And KISS is a bacon company, right? It's like Trinidad. I think KISS products are in Guyana as well, right? I know Guyana have a lot of Canadian-based products as well. But I've had 2 students who had experiences with PriceMart and KISS, and students of mine then, and having me shared 2 other stories of somebody in the electricity company here in Trinidad, and another instance, they came back to me, and the long and short of it is that they sued those companies and they won their cases. Right now, today, I can't tell you much details on this one, right now, today, I am like an expert witness in a case of a student who was injured in a company and who is suing the company. I can't call the name of the company, but it's one of those bigger companies in the Point Lisa's industrial estate, right? And to tell you, it's a real case. The name of the company starts with Y. So there's only a few companies that start with Y. Y is a strange letter, right? So just to let you know, this is a real thing. I also had one of my lecturers, past lecturers. He's not current, so he's not even in Trinidad. I had a past lecturer. I could tell you this one because this is a past story. I'm telling you to tell you that this is not a joke, right? This is when we talk about this, and it have real people that's get injured, students. If I tell you the one in PriceMart, I'm not going to, right? It's real people, right? So I had a lecturer who at the time, he's no longer there at all. He's not in Trinidad. A fire truck, a fire engine then, and he was a fire officer, rolled over his foot. The long and short of this is that he did nothing. If I didn't tell you the story before, until I met him by one of the Pizza Huts we have in Trinidad. The long and short of that is that I told him what he was doing, I told him what he could do, and he did do it, and he did sue the fire services and won a lot of money, right? How did I know he won a lot of money? By the way, he didn't give me $1, just to let you know. Just to let you know. He used to come to class with a Nissan 80 wagon to teach on a Saturday. And then when he won that case, he came with a high-end vehicle, a vehicle that was worth more than 300,000 to 400,000 TT dollars, right? So this is real thing I'm telling you. And like I said, even the present case I'm on now is a real student that has been injured in a company, right? And when I told you precedent, I wasn't telling you this for a joke, right? Like in my report to the judge, who do you think I quoted? Who do you think I quoted from here? Which precedent case did I quote to talk about the company would have been negligent? Anybody could guess? It's in your book. The precedent case I quoted would have been Donahue versus Stevenson. Even though this lady lived and died in Scotland, and I'm in Trinidad, in San Fernando, Trinidad, 2024, dealing with a company that starts with Y, I still quoted the same case. You all understand what precedent is? Precedent means it's a precedent for the world to follow. Trinidad, a small, tiny island that people seem to think is New York City, right? It is applicable here in Trinidad. It's applicable in Guyana. It's applicable wherever you are. And like I said, that's why, you understand why I put this slide here now? That's why there's a memorial to Miss May Donahue, because people benefit from her decision to sue the company, right? That case has been taken into the world of law to be a precedent case, right? All right. If you want, cast your eyes to page 17. I tell you, I wish I could have tell you this is a passive, but it's not. It's just really good stuff till you reach the degree level, if you intend to do all of that. Not everybody have to do it. It's not meant for everybody, right? All right, so claimant for negligence. If you look to the top of page 17, you'll see the same thing. Sorry, just now. I think no, for you it's page 16. The duty of care, page 16. The claimant, if you look at page 16, must prove their case on a balance of probabilities, and you have the three things you have to prove, right? Now, when you say the claimant is you, now you could represent yourself if you know what you're doing. But it may make some sense to hire a lawyer. Not all of them expensive. Not all lawyers are expensive, right? And remember, this school hasn't been here yesterday, right? This school, we have been here more than a decade, right? So I've had two of my students, just to give you a long story short, that went on to do the degree. The degree has a lot of law in it, which is good. A lot of law cases like Donahue versus Stevenson. Anyway, after that, they became lawyers. I have two of them today. So they assist you. Sometimes when a student call and say, sir, I need some advice, I would just call on Brandon. I say, Brandon, here what now? A student spoke to me and he said that he was injured. Could you give him? And Brandon doesn't charge anything. Brandon was a student here, right? Now, eventually, if they take your case, they would charge something, but they are not high-end lawyers then. So they're not going to charge you much, right? I have Brandon and I have Kamini. Any one of you that, that think about, or maybe, God forbid, something has happened to you, health and safety wise, right? Not if it's family wise, then you need to find another lawyer, family lawyer. But these are two students of mine that over the years that are now practicing lawyers, right? And initially they talk to you free of charge. It has nothing to do with me. I would just pass the numbers on to you. And this is what has happened. These stories are telling this is how it happened. And those persons are in better cases today, right? I do not know anybody in Guyana, so I don't know any lawyers and stuff in Guyana, right? So for the folks in Guyana, it may be different, right? But what I was saying, you could represent yourself. It may make sense to get a lawyer next to you. And what you have to prove. So when I say you, is you or your lawyer, you have to prove these three things you see in here worldwide. It doesn't matter if in Guyana, Trinidad, Scotland, doesn't matter, right? The lawyer have to prove, you or your lawyer have to prove three things. Now, this is if it reads so far. I don't know if you all understand that. I don't know if you know that. This is if it reads so far, right? Initially, when you talk to like a lawyer for a company or an employer, they send what is called a pre-action protocol letter. Most lawyers will do that for about $500 TT. If you get a cheaper one, fine, right? But most companies, when they see the pre-action protocol letter, they may settle the matter. They will try to settle it outside, right? They will try to say, well, what do you need, etc., 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 right? So it doesn't have to reach before a judge. I don't know if you know that. Do you all know that? It doesn't have to reach before a judge, right? You have certain stages of the pre-action protocol letter where the employer or your neighbor, if your neighbor did, something on your land or something, move your fence or had oil or something on your property, you can still send them the pre-action protocol letter, right? Most lawyers, if you have a lawyer friend, they can do it for you free, right? But that is the start of legal action. And then most companies, when they see that start, they try to settle outside because they don't want to go to court. They don't want their name dragged through like the court system, right? So most persons settle outside anyway. So it doesn't have to reach before a judge. But here, this slide, and in your book, page 16, this is if it goes before a judge. So you have to prove, or your lawyer, that a duty of care was owed, right? You have to prove a duty of care was owed. Now, how could you prove that? Let me see if I can get a marker here. How could you prove a duty of care was owed? Now, we are going to stick to employee, right? Of course, if you are a neighbor to somebody else, that is also a duty of care. Because remember what Lord Atkins said, that neighbors have a duty to take care of others then who could be affected by their actions or their failure to act, right? But we'll stick to employee. So anybody, I don't know if you're following or you're kind of lost because I'm saying a lot at the same time. But how could you prove then how could you prove your employer have a duty of care to you? How could that be proven? Because court is all about proving. How could you prove the employer have a duty of care to you? If you want to take these things down, like I said, there is no exam question today, but it could never tell. There's no past exam question. That doesn't mean it wouldn't have one, right? Okay, this marker running real funny this morning. So this was supposed to be the word employer, and it wasn't supposed to be this big. But if you want, I could give you a start, but I don't want to give you all the answers, right? How could you prove that the employer have a duty of care to you? How could that be proven? How could it be proven that you are an employee of Atlantic LNG? How could it be proven that they have a duty to you? How could that be proven?
So any duty to the
Contract.
employer, the section
Okay, let's
whatever.
get Vincent first. Vincent.
The section 2 have whereby the duty employer deserves state, no?
Okay, let's get the other one. Was it Desan?
Most cases, a contract would have been drawn up before you started working, outlining what your responsibilities are, what the employer's responsibilities should be to you as well. And then we have from the HSC the responsibilities of the employer.
Very good. Hey, but you all are really bright people because those are the two best answers, right? So the two best answers is the duty of the employer is in the HSW Act. I think Vincent even said it. He said Section 2, right? Section 2, this is the answer for examiner. And the other answer, the only possible answer is a contract, right? So, there's nothing for me to say here again. Could you just finish up this word, right? This is a fairly new computer using, so I'm not too sure how I am doing the normal thing I normally do, but I'm not too sure why the letters coming out that big, right? And the other computer doesn't come out that big. Yeah, so a contract, I have nothing else here to say. So a duty of care could be shown from the HSW Act if you want to go back and take a look in the book. But things like the duty to provide safe access and egress, the duty to provide supervision. I don't know if you remember that, if you could remember the section as Section 22C, right? So if an employee was not supervised, right? Well, the employer have a duty to provide information, training, instruction, and supervision, right? So if they didn't provide supervision, but then they broke that duty. And the other one, yes, is a contract would have been drawn up, right? A contract, TRACT, a contract would have been drawn up between the employer and the employee, right? You want to hear a funny story here in Trinidad? Again, I'm not calling the company name, but the same company that injured the student that in court right now. Last year, they had another one of my students there too. And it had an injury with the student, right? So while she was talking to us, right? She was in the class, so she was giving us the story. So while she was in the ambulance being transported from the company to the hospital, the company called her. You can imagine what I can tell you now. The company called her and tell her that they no longer need her services, right? And that they have to let her go. And I don't know if you understand what they were trying to do. Anybody could say what they were trying to do? What was that company
Absolve
trying?
themselves of responsibility as far as the contract
they
is
they
concerned.
were trying to terminate the contract, right? And here how worse it was. Now, like I said, at least they have us in class here, right? So here how worse it was, right? After that, I guess after the hospital treatment, they decided to say that she was never working for them. She was never employed, right? So our defense for that would have been, well, was she a mad lady to enter the compound every day for the last year and no one noticed that a mad woman was in the compound, sitting in her desk doing work? What about her pay slip? So they were just paying money to somebody who just walked in the gate and she was getting a pay slip. So some employers, right? And you'll see this if you want to watch page 17, you see the word defense, right? So when you say the duty of care was owed, the employer is going to try to defend himself. What's the first thing you see on top of page 17? What is the first thing the employer trying to say? You are saying a duty of care is owed. What could the employer try to say? The first thing on page 17 is what? The first one in bold, the first bullet point. You'll have it?
No duty of care owed.
Yeah, they can try to say no duty of care owed. So it's a defense, right? You remember you all did you all see the case with Johnny Depp and Amber Heard? We must have all seen it. It was all over Facebook, TikTok. Remember the thing with Johnny Depp and Amber Heard? You remember those two persons? I think everybody had seen that on, was I think 2022. Anybody remember that? You remember the Johnny Depp trial, right? Yeah?
Yeah.
Okay, good. All right, time slip, right? So the point they're trying to say is that a court case is like a battle. It's like you have two sides then, you and the employer. So you trying to say one thing, the employer trying to say something else, right? So in the one I'm doing right now, telling you, I did the report up to last week. Company Y was trying to say, I'm trying to remember, but they had a very weak defense, right? They were trying to say things like they did a risk assessment, right? So they did a risk assessment, fine. But for those who know what a risk assessment is, a risk assessment must be something called suitable and sufficient. You cannot just do a risk assessment. It must be suitable and sufficient. It must be suitable then, right? So how I sort of shot holes in that was saying that the worker had to access like a work area, but he had to pass on pipelines. Now you don't really have to pass on pipelines because anybody know you could actually build like a railing system and put it on the
That way.
pipelines. So, yeah. So saying that and they did this for 40 years, right? So saying, yeah, the company said they did this for 40 years and nobody ever slipped. But my thing is, the fact that nobody never slipped didn't mean that it didn't have the potential for somebody to slip because you are walking on pipelines, rounded pipelines. For those who know what I'm talking about, pipelines, like a rack then. If you know what a rack of pipe, it's like that, a rack of pipelines. But you know how to walk on pipelines, you can just build a walkway and put it on it, right? So you have a fence, the worker will walk on a smooth surface and then you have the handrail. So my thing, and that was like one of many that like for me, they did not provide adequate safe access and egress. Because how could the method of getting to the workstation be walking on pipelines? You understand? Walking on pipelines is not suitable access and egress. But in this case, I'm telling you, it's all about a defense then, right? So if you look at it side by side, as you have your book, I haven't turned this what you're looking at on page 17 is on my next slide. But as you have your book, you could watch all one time now. So on this slide is seeing what the claimant have to prove. A duty of care was owed. The next thing, you have to prove a duty of care was breached. And the third thing, it's in your book, you have to be able to prove that you suffered some sort of injury or loss, right? So like in the student case now, question for me, anybody? Yeah?
Yes, sir. Another thing is they didn't provide a safe working environment.
Yeah, I just give two here as a whole, as a 10-page report I did, right? But I told you I had, as a teacher, negligence today. I went back to negligence, right? I spoke about, you know, that the company is negligent, right? I did other things, but there's a lot more law cases then, but as these are relevant to what we did, I'm showing you that these things are applicable even in a present case in Trinidad and Tobago, right? And around the world, this is it. This is how it is, right? So if you have things like medical reports, which the student have, the one in PriceMart too, the lady in PriceMart had spinal injury and she didn't take them to court. She was in a class of mine and she heard I shared another story as how today I am sharing her story, right? Shared another story and after the class she came to me and she had spinal injury. She was well compensated, but spinal injury means a lot of pain. In the event of the student I'm talking about now, the other guy, I'll just call him P because his name starts with the letter P. P has had a knee surgery. right? He has had a knee surgery, right? And of course, I'm not too sure if you understand all of this because this is just level 3. There's more to this. The injury and loss could also be things like your loss of life, but not just when I say life here, right? I should rephrase that. Okay, loss of your quality of life, right? Like if you used to go hiking and because of a knee injury, you cannot go hiking anymore. If you used to go cycling because of a spinal injury, you cannot go cycling anymore. You are compensated based on the loss of your quality of life. There's actually a formula for that at the degree level. They calculate how much more years you have to live. So like if you're in your 20s, they go up to 70 and they check you are compensated for each year of your life. I don't know if you know that. That's how the compensation goes. It's called the quality of life, right? So if you're in your 20s, you're injured, in 30s, you're injured, they calculate how much the rest of your life, up to about 70, could be affected, and you are compensated based on that, right? Anyway, that's diploma stuff, right? For now, the 3 things the claimant have to prove: a duty of care was owed, the duty of care was breached, because of the breach you suffered some sort of injury or loss, right? Let me get to the other slide. It's going to line up with what you see now on page 17, right? So as I did say, a court case is like a battle, and having you said your side, the defense have to say their side, right? So these are the possible defenses to any employer. Now, I don't know if you know this, right? Well, you all know I am a consultant, right? I've told you that, I work as well. So, so sometimes, right, the people that come to me is not students. And in that case, I take the company side. In that case, I shoot the hose the other way around. At least I try. I've had 2 companies that hired me already to work on a law case for them, right? One of them had some debts in Tobago. A ready-mix company. It was all over Facebook. So I wouldn't call their name, right? And the other one was also, well, this company is actually in Tobago, right? And so it depends on who my client is. If it's a student, I'll take the student side. If it's the employer, I take the employer side. Now, it's just my job to say, because some students could be lying. And have people, when I say students, some people could be lying. Some students could say, look, I fell long and I have this injury. But then you have witnesses who see them playing football, right? So it depends on who my client is, right? So I prefer something's be on the side of the worker, but it all depends on who called me, right? So could I tell you all a strange one? Could I tell you a strange one? So a strange one was also PriceSmart, but in this case, I was on a company or a subsidiary side to a company in PriceSmart. So it wasn't a student side, right? Anyway, the long and short of this was that a knife, I don't know if I told you this, a knife right in Trinidad here, a knife went into a bag of oats. There's a packing company, the companies that pack stuff for PriceSmart. And apparently a worker rested knife, but it's on a conveyor now. And the conveyor will take a certain amount of oats, put it in a bag, and it's sealed. But the knife was on the conveyor. The worker didn't realize he rested the knife there. And the knife got packed into a bag of oats and went to PriceSmart. And of course, a lady bought it. And of course, you all know how the story goes. Some child opened it. And when the child opened this bag of oats, it had a knife, a big knife. Well, not a big knife, but a bigger knife. Not a huge knife, but a good sized knife. So of course, she sued PriceSmart. But in this case, I was on their side. So, I did some stuff to say that at least in that sense, PriceSmart was not responsible then, right? So those things are still before judges, those decisions, these things take years. The thing with the students are telling you about, that actually going on since 2019. Right? So when the decisions is made, I'm not a judge. I just do what I could do to help my clients out, right? If it's students or companies, judges will have sense and they will make, the sense or the best sense out of what I have produced anyway. All right. Anyway, so some defenses of the employer considered you were contributory negligent. Meaning, so maybe you slipped and you fall, but probably you were running. Probably you didn't look where you were going, right? As in the case of me being decided a student, no, remember, I wouldn't say something like that. I would flip it the other way and say the company is responsible, right? But it all depends, like I said, this is the thing about a battle. This is the thing about a boxing match, right? Is how best you throw your jabs anyway. Another thing the employer can say, they can say that you willingly accepted the risk. You knew the place was slippery and you went there anyway, right? There's a Latin phrase for that. The Latin phrase is volenti non fit injura. It means to the one that is willing, if you willingly did what you did, then no harm is done. Let me read all of them, right? Another defense is the risk was not foreseeable. We can say we did not know the worker was going to slip and walk on the pipeline. Now remember, this is not true. When I say not true, I'm actually not on the company side in that one. I'm just imagining if I was, I would have said something like that. I would have said that the risk was not foreseeable. What the attempt is to produce a defense. Remember, there's a judge. Let me try to draw that for you, right? What I do is what I do. There is a judge. What I do, if I'm on the employer side or the student side or the worker side, a judge have to make sense of what we are saying, right? It's up to the judge. Our thing is just to produce the information, right? So this is you, this is the employee, this is the employee, you, and this one here would be the employer, right? So our thing, whoever is the client, we produce the information. A judge sitting there will have to think about what we are saying, or what the lawyer is saying, and say, this doesn't make sense. The company is responsible, and that's what they should say, right? But it all depends. This is a possible, in a boxing match, then it's a possible job. It's a possible job. It's a possible defense. It's a possible block. It's up to the judge to decide if it's making sense or not, right? So as you see in your book, some of the things they can say, a duty of care was not owed, you are not our employee, or you are the employee, but no breach, like we didn't breach the OSHA or we didn't breach the HSW Act, or no loss was incurred, you are lying, you did not suffer any broken bones, someone saw you playing football, right? Whatever have you, right? Another defense is you are off on a frolic of your own. This one would only make sense if you ended up somewhere that you were not supposed to be, right? So like they sent you from Georgetown to Berbice, but you end up on the seawall buying food Friday night or Sunday night. For those who don't know, I actually experienced that. Sunday night in Guyana is actually brighter than Saturday night in Guyana, right? So you ended up on the seawall, but you know, you had to go down Berbice, but you ended up there and, you know, something happened, an accident or something happened there with the company vehicle. Well, they can say even if you were injured in the company vehicle, but you were not on your route, you're out on a frolic of your own. Those of us in Trinidad is very similar to say a company would have sent you to Point Fortin, but you end up in Maracas with a company van. And you made an accident and you got injured and you're trying to sue the company now, Massey, because Massey have money. But what are you doing in Maracas? The Point Fortin is way on the other side of the island, right? So, like I said, the defense is there to be fair to both employer and employee. There are some employees who may want to sue their companies just to get money. So there's a possible defense, right? Another defense is the time to make the claim has passed. I think this is about 3 years from the discovery of the harm. 3 years from the discovery of the harm. So the student I told you about, sorry, not student, the lecturer that I told you about when I met him in Pizza Hut, right? It was actually a year after the injury and a year and a half. I saw him. I can call his name because I tell you he's not here anymore, right? He's in Canada. I said, Christopher. Because Christopher, I said, like, what happened? Because he was limping, right? And then he told me what happened a year ago. And I said, you took any action against the fire services? And he said, no. Well, you know where that ended up, right? I told you about the vehicles and stuff, right? So if more than 3 years pass from the discovery of harm or from a medical diagnosis, well, then you can't make the claim anymore, right? So if it's within the 3 years, though, of the discovery of harm, again, there's a lot of stuff that you might not understand there. How could I say this? Some people, when an accident happened, especially men, they don't say anything, right? So like something fall on your foot, a pipe fall on your foot, but you're okay. You say you're okay, right? or something happened, you lift up something heavy, and even I guess probably the ladies, you say something, we say nothing is wrong. But later on, then 6 months down the road, when the pain starts, right? So that's why they give you 3 years of the discovery of the harm. It may be that you started to have the back pains, maybe whiplash, maybe something that hit you on your back in the company, some lever, some crane or something. But at the point in time, you didn't really take it on. But, 6 months down the road, you go and you get some, get some x-rays or whatever have you. You get a scan and you realize that you have a bit of a slip disc, right? So that's why they give you 3 years of the discovery of the harm. Folks, you'll understand it? Hope you're making notes. But like I said, no
why,
exam question,
so
just
excuse-
good stuff. Yes, go ahead, Darren.
yeah, so why 3 and not less?
Well, because some things are chronic, like what could cause harm? Well, it's no, you don't have to wait for the 3 years in a Daryl. You don't wait for the 3 years in a. If you decide if something happened today and next week you decide to sue, fine. But what they say is that sometimes pain is progressive then, or some things are chronic, if you understand what that means. Like, okay, I had a worker, this is a true one, right? The guy named is Steven. Somebody took an air horn and blew it in his ears. Right? So no, he was taken to the company doctor for that because that's a serious thing, right? But what I'm saying is that later on, 6 months down the road, if it is found out that he has some sort of permanent hearing loss, then certain things are chronic. And what chronic means? Chronic means it will take some time. Or certain things then could be hidden. Certain forms, and like somebody exposed to dust, you're doing some work removing some ceilings, you were exposed to asbestos dust, but you didn't know, right? 6 months from now, you develop a cough, the cough turned into a serious cough, you check with a doctor, they said, here what? You have asbestosis, which is a type of cancer, right? So certain things, they like certain ailments, as they affect you, it may get progressive as years go by, right? So they say 3 years from the discovery of harm. You got the last part? 3 years from the discovery of harm, right? So so I don't know if you understand that. It may actually be more than 3 years, right? It may be that it's 6 years. I don't know if you get that. So a proper way to say it is 3 years from a medical diagnosis. So you could have left the company 10 years now. You left one of the powdered companies, one of the flour mills in Trinidad or in Guyana, or one of the gold mining industries in Guyana, because this is famous across there too, right? And so you worked there for 10 years, but then 2 years after you left, you discovered that you have some kind of cancer. Now, it's actually 2 years of the discovery of harm. So you can still sue that company because you have up to 3 years from a medical diagnosis to sue a company, right? But the defense is, if I am on a client side, if I'm on a company side and you come 5 years after a medical diagnosis, my defense is, well, the law only permits a civil case for 3 years of the discovery of harm. It's now been 5 years this person knew that they had cancer, right? So in that case, now again, remember a judge, Judge Judy, it wouldn't really be Judge Judy, I just say it, right? Judge Judy is still listening, but the judge would have to be bound by the principle of law. So if they only allow 3 years, but then they have to throw that case. In that case, my employer would win or my client will win, right? So that's how it is, though, right? But other than that, I mean, once you know this fact, if you know this fact, fine, right? 3 years from the discovery of harm, right? Have you all ever seen, did you all ever see the movie Liar Liar with, you probably did with what's his name? With Jim Carrey. You all ever saw that movie? Liar Liar. You ever saw that movie? You probably did, but was years ago. You probably did, but was years ago. I haven't seen it in years. I haven't seen it in more than a decade. But you all know who Jim Carrey is, right? You know who Jim Carrey is? This generation may not know who Jim Carrey is. For those of us who grew up in the 90s, though, Jim Carrey, you all know who Jim Carrey is, right? Yeah. Anyway, you must know.
Jim Carrey.
Yeah, but no, I mean, Glenn and some of us here, I mean, this generation don't quite know, but Jim Carrey was in a movie called Liar Liar. It was a court case as well. And that's how he won in the end. He won the case. He won the case because the state of California had only allowed a certain number of years. And when he found that out, that's exactly how he won the case. Right? The case was shown up because the number of years was actually passed. Right? All right, folks, that's the we just have one more thing to do and we finish today. And I'm gonna clean this slide here. So if you look down to the bottom of the book, if you turn the page, you'll see what I mean, the class finished. If you turn the page, you'll see we actually finished. There's just two more things to do. And there's just two more words to learn, right? Which is something called contributory negligence. It's on the other slide. And then vicarious liability. None, zero has ever come for exam. I don't know why. Such a good part of the course. They leave it for the diploma, I guess. But again, like I said, it's not off the syllabus. It's just not there, right? What is vicarious liability, right? So vicarious liability, I'll read this slide first. An employer, this is something that we could use on the client side or on the student side if the client is a student, right? An employer will be vicariously liable for the negligent action of employees during the course of their employment. So listen to that. Even if you were negligent, even if you stepped on the pipeline, just saying, right? But that was how they had to get to the skid, right? SKID. But even if they were being negligent, because the person was acted in the course of the employment of their work or their job, the employer will be liable. That's a duty called vicarious liability. Vicarious liability is very similar to schools. Adnan may understand what I'm trying to say, right? Like parents and students and principals. Those of us, if you have any kids, Adnan worked at a school before. If you have a child, right? Or you have younger siblings, brothers, sisters, right? And you drop them to primary school. I say in primary school for this example, right? Not secondary school. And something happened to the child. In the eyes of the parent, who is responsible for that? Tell me, who should when you okay, but who in the school? If your child fall log in school, right? Who is responsible for that? If you were the parent hearing
Teachers and
that,
principal.
the principal responsible. And that's the same idea you're seeing here, right? If the parents say, I'm going in school, who they going for is the principal, right? So that's vicarious vicarious liability. So the same way, if something happened to the worker, who is responsible? The employer. The employer then is seen to be the parent, the parental figure of the worker, right? So the concept of vicarious liability is that if a worker is injured, the employer is responsible. That's the concept, right? I could tell it another way, but this would just be parents and children now. If I guess we could all identify with this one, even when you were a child, I guess. If a child was playing cricket or football, bat the ball or kick the ball and it breaks the neighbor glass, who is responsible? Who's responsible for replacing the glass or the light?
The parents.
The parent.
Okay, but who it is hit the ball?
Your child.
The child,
Child.
but who's responsible? The parents. Is the same thing. You
Yeah.
understand? So if the employee fell, fine. But who is responsible? The employer. If the child hit the ball and break the neighbor glass, who hit the ball? The child, but who's responsible? The parent. That is vicarious liability, right? So this is a very good concept in law for students. When I say students, like workers then, right? The fact that you fell, this is what I told you I used in one of the claims, and the fact that the worker fell meant that the workplace was unsafe, right? Because if you go to work healthy and you fall along on work, well, then something had to be wrong on work. If something is wrong on work, who is responsible for what goes on at the job site? It's the employer, right? Anyway, I said I would let you all know. You all may not be with me when that happened, when that case finally, the final decision is made. But who knows, maybe if you come in a degree, I'll remember telling you all, remember that case in the company that starts with Y. And because we don't know what the judge will say, but I think the judge will take the student side. There's a reason for saying that. I don't know if you know why. I could tell you why, right? Listen to the reason. Civil law, top of page 16. The purpose of civil law is to give, how to say it? It's to give people money. That, I guess, is the simplest way to say it. The purpose of civil law is to give justice. That's it. The purpose of civil law is to give justice. And justice in civil law is seen via money. In other words, if you are injured, the judge will feel pity for you then. That's how it is. Civil law exists to compensate victims. Hear what I said? Civil law exists to compensate victims. There's no other purpose of civil law. You don't go to jail in civil law. You don't. It's just somebody suing somebody. So they exist for compensation, right? The last word for today, well, I think I passed it. Or was that it? I think that was it now. We're going too fast now, right? So if you notice what I did on this slide, we come back to the part where they act in it, but we had done this already, right? Yeah, I think that's it. There's nothing else, right? So let me check out your charts. I guess we finished a bit early today. I wouldn't start chapter 2, but next week is chapter 2. I'm gonna have to send you some new PowerPoints. And let me just read some of your comments now, right? And when we start a new chapter, the good news is there'll be new questions, right? There'll be questions on chapter 2, right? So I just have to remember to send you that PowerPoint, right? You have to get a new PowerPoint for next week, Saturday, as we will be starting chapter 2 next week, Saturday, right? Let me check out your comments. Okay, Christina, isn't that a statement that most employers use, although they are fully aware? But the thing is, yeah, everybody will try to defend themselves. Remember, there is a judge if it reaches the court, right? Let's see again. Marsha, what if you were injured in an accident, but you really was not in pain at the time? So that's what the purpose of it is, right? So you didn't go to the doctor. And that is the case I'm dealing with now. The student, he didn't go to the doctor. I said most men is like that. He slipped, he fall on the pipe, he said he was okay. They asked him if he want to go to the doctor, he said no, right? But the following day though, he did go to the doctor, right? So the thing there, right. But he did go, right? Masha case is a bit different here. Documentation. So to get any medical documentation to prove anything, and 2 years or more has passed. Well, if it's 3 years, still, you still have some time. The question here for Masha is the person still in pain? Is there still some kind of loss still? If not, you might not win the case. But if it was progressive pain or progressive injury that the pain has gotten worse, even though you didn't initially do it, you still have the 3 years, right? So that doesn't make it wrong or anything like that. You still have the 3 years to bring that company up in court. Okay. Amika said, I did the diploma in OSH at UWI. UWI has a diploma in OSH. I'm not aware of that, right? During the course of this program, I remember saying something about the company being liable for up to 40 years. Nah, never. Right? Not in the Trinidad OSHAC, not in anybody OSHAC. The number 40 does ring a bell, but it's not with that. It's something with a UK law called COSH, right? But it have nothing to do with injury anyway, right? The law is the law in any country you go to, it's the same anyway, right? Yeah, okay. So no, it's not 40 years, that doesn't exist. It's 3 years of the discovery of harm, right? Let's see again. Okay, I think that's it on the charts, right? So I'll just call the roll, I think, for today, right? So folks, my advice is to read up the rest of chapter 1. There is something on contractor management. What I do that in chapter 3. If you look at 1.4, contractor management is actually part of chapter 3 as well. So we do it there one time, right? So the next thing from here, based on the syllabus, is chapter 2, policy. A very nice chapter, very nice content, nothing hard. And again, new questions because chapter 2 has questions on it, right? The rest of chapters have our questions on it, right? So this is just our 1, 2, 3, 4, 5. This is our 6th session. I don't know if you'll ever check. It's about 15 sessions we have in all, 15 to about 18 sessions and all. So we are making good headway anyway, right? Let me stop the recording here. If I could. Let me see. Right, this Zoom is a bit different than this computer. Anyway, okay, yes, I saw it.